Metropolitan Commons, Mitcham, Supplemental Act, 1891. Chapter 26. An Act to confirm a scheme under the Metropolitan Commons Act, 1866, and the Metropolitan Commons Amendment Act, 1869, relating to Mitcham Common, Upper Green, Lower Green, Figs Marsh, and Beddington Corner, 11th May, 1891. Whereas the Board of Agriculture have, in pursuance of the Metropolitan Commons Act, 1866, and the Metropolitan Commons Amendment Act, 1869, duly certified a scheme for the establishment of local management with respect to Mitcham Common, Upper Green, Lower Green, Figs Marsh and Beddington Corner, situate in the parishes of Mitcham, Beddington and Wallington, or one of them, in the county of Surrey. And whereas the said scheme is set forth in full, in the report which was made by the said Board for the year ending the 31st day of December, 1890, and which was duly laid before both Houses of Parliament. And whereas, by the said Metropolitan Commons Act 1866, it is provided that any such scheme shall not of itself have any operation, but shall have full operation when and as confirmed by Act of Parliament, with such modifications, if any, as to Parliament seem fit. And whereas it is expedient that the said scheme should be confirmed, be it therefore enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal, and Commons, in this present Parliament assembled, and by the authority of the same, as follows. 1. The scheme for the establishment of local management with respect to Mitcham Common, Upper Green, Lower Green, Figs Marsh, and Beddington Corner, situate in the parishes of Mitcham, Beddington, and Wallington, or one of them, in the county of Surrey, certified by the Board of Agriculture under their seal on the 31st day of December, 1890, and contained in the schedule hereunto annexed, is hereby confirmed. 2. This Act may be cited for all purposes as the Metropolitan Commons, Mitcham, Supplemental Act, 1891. Schedule. The Metropolitan Commons Act, 1866, and the Metropolitan Commons Amendment Act, 1869, scheme with respect to Mitcham Common, Upper Green, Lower Green, Figs Marsh, and Beddington Corner. 1. The pieces of land with the ponds and roads thereon, commonly called or known by the names of Mitcham Common, Upper Green, Lower Green, Figs Marsh, and Beddington Corner, hereinafter collectively referred to as the Commons, situate in the parishes of Mitcham, Beddington, and Wallington, or one of them, in the county of Surrey, as the same are delineated in a plan deposited with the Board of Agriculture and thereon coloured green, shall henceforth for all the purposes of this scheme be regulated and managed by a body of conservators. 2. The first conservators shall be one person to be appointed in writing by the Lords for the time being of the several manors within which any portions of the Commons as defined by this scheme may lie. 4 persons for Mitcham, hereinafter called the Mitcham Conservators, elected by the vestry of the parish of Mitcham, namely George Parker Bidder, Q.C., William Wright Thompson, Francis Tomlin, and Richard William Shackle. 4 persons for Croydon, hereinafter called the Croydon Conservators, appointed by the County Council for the County Borough of Croydon, namely Frederick Thomas Edridge, J.P., Thomas William Dobson, Robert Josiah Hinton, and David Buck Miller, J.P. 2 persons for Beddington, hereinafter called the Beddington Conservators, elected by the vestry of the parish of Beddington, namely Simpson Rostron and Brew Maltby, and 2 persons for Wallington, hereinafter called the Wallington Conservators, elected by the vestry of the hamlet or parish of Wallington, namely Alfred Hutchison Smee and Edward Ellis. 2 of the first Mitcham Conservators, 1 of the first Beddington Conservators, 1 of the first Wallington Conservators, and all the Croydon Conservators shall go out of office in the month of April next following the confirmation of this scheme by Act of Parliament, and 2 of the first Mitcham Conservators, 1 of the first Beddington Conservators, and 1 of the first Wallington Conservators in the month of April in the succeeding year. 3. At some meeting of the Conservators, held before the month of April next following the confirmation of this scheme by Act of Parliament, it shall be determined by lot which two of the first Mitcham conservators, which of the first Beddington conservators, and which of the first Wallington conservators shall go out of office in the said month of April, and which in the month of April in the succeeding year. 4. The conservators, other than the first, shall consist of one person to be from time to time appointed in writing by the Lords for the time being of the said manors, 4 persons to be elected by the vestry of the parish of Mitcham, 2 persons to be elected by the vestry of the parish of Beddington, if the vestry shall exercise its right of so electing conservators, 2 persons to be elected by the vestry of the parish of Wallington, if the vestry shall exercise its right of so electing conservators, and, subject to the provisions herein after contained, 4 persons to be from time to time appointed by the County Council of the County Borough of Croydon. The term of office of the conservators, other than the appointed conservators, shall be 2 years, and the 2 Mitcham conservators, and the Beddington conservator, and the Wallington conservator, who respectively have or has been longest in office without re-election, shall go out of office each year. 5. Election of conservators in the place of those going out of office shall be made by the vestries of the parishes of Mitcham, Beddington and Wallington respectively, at meetings to be held in the month of April. 6. Subject to the proviso. Herein after contained the County Council of the County Borough of Croydon, at some meeting to be held in the month of April next following the confirmation of this scheme by Act of Parliament, shall, by a resolution to be passed by a majority of the members then present, appoint 4 persons to be conservators, such persons to continue in office for such term as the Council by the same resolution shall prescribe, and before the expiration of such term, or of the term for which any future conservators shall be appointed under this power, shall in like manner appoint persons to be Croydon conservators, provided always that the Council shall not exercise the power of appointing conservators, hereby conferred upon it, until the Council shall have entered into an agreement under seal with the conservators to pay to the conservators annually a sum equal to 1/3 of the expenditure incurred by the conservators in executing this scheme, such sum not to exceed, without the consent of the Council, £100. 7. The Lords for the time being of the said manors may from time to time in the month of April in any year cancel the appointment of any person appointed by them as aforesaid, and appoint in writing another person to be a conservator. 8. Any conservator, after going out of office, resigning, or otherwise ceasing to be a conservator, may be again elected or appointed a conservator. Should any vacancy in the number of conservators arise by death, resignation, or otherwise between the times fixed for election or appointment as aforesaid, or if at any time there shall not be a full number of conservators, the conservators for the time being shall continue to be as competent to act as if no such vacancy or deficiency in number had occurred, provided that, in the case of any vacancy occurring, the Lords for the time being of the said manors, or the County Council of the County Borough of Croydon, or the vestry who or which appointed or elected the conservator ceasing to be a conservator, shall, as soon as conveniently may be, appoint or elect, as the case may be, some proper person as a conservator to supply such vacancy. But the person so appointed or elected shall retain his office so long only as the vacating conservator would have retained the same if no vacancy had occurred. 9. No bankrupt or insolvent or person who has compounded with his creditors shall be capable of being or continuing a conservator. 10. No conservator shall receive any remuneration or hold any office of profit under this scheme. 11. Any act of the conservators shall not be invalidated or be illegal by reason of there being any vacancy among the conservators, or by reason of any person not qualified or ceasing to be qualified, acting as a conservator, or by reason of any irregularity, failure, or omission whatsoever in or about any appointment or election of conservators, or in or about any matter preliminary or incidental thereto. 12. The Conservators shall hold meetings for transacting business under this scheme twice at least in every year, and at such other times as may be necessary for properly executing their powers and duties under this scheme, and shall from time to time make regulations with respect to the summoning, notice, place, management, and adjournment of such meetings, and generally with respect to the transaction and management of business by the Conservators under this scheme, provided always that no business shall be transacted at any such meeting unless 3 Conservators at least are present thereat, and all questions shall be decided by a majority of votes, and the names of the Conservators present shall be recorded, and the Conservators shall annually appoint one of their number to be chairman for 1 year at all meetings at which he is present, and in case the chairman so appointed be absent from any meeting at the time appointed for holding the same, the Conservators present shall appoint one of their number to act as chairman thereat, and in case the chairman appointed as first aforesaid shall die, resign, or become incapable of acting, another Conservator shall be appointed to be chairman for the period during which the person so dying, resigning, or becoming incapable would have been entitled to continue in office, and the chairman at any meeting shall have a second or casting vote in case of an equality of votes. 13. The Conservators may from time to time provide and maintain such offices as may be necessary for transacting their business, and that of their officers and servants under this scheme, and shall cause to be made a seal for the use of the Conservators under this scheme, and documents or copies of documents purporting to proceed from the Conservators, and to be sealed or stamped with such seal, shall be received as prima facie evidence in all courts and places whatsoever. 14. The Conservators shall cause entries of all proceedings of the Conservators, and of every committee appointed by them with the names of the Conservators, who shall attend each meeting, to be duly made from time to time in books to be provided for the purpose, which shall be kept by the clerk under the superintendence of the Conservators. And every such entry shall be signed by the chairman of the meeting next after that at which the proceedings took place, and such entry so signed shall be received as evidence in every court and before all judges, justices, and others, without proof of such meeting having been duly convened and held, or of the persons attending such meeting having been or being Conservators or members of committees respectively, or of the signature of the chairman, or of the fact of his having been chairman, all of which last mentioned matters shall be presumed until the contrary is proved, and such book shall at all reasonable times be open to the inspection of any of the Conservators. 15. The Conservators may from time to time appoint and employ a clerk, treasurer, common keepers, collectors, and other officers and servants, as may be necessary and proper for the preservation of order on and the enforcement of bylaws with respect to the Commons, and otherwise for the purposes of this scheme, and may make rules for regulating the duties and conduct of the several officers and servants so appointed and employed, altering such rules as occasion may require, and the Conservators may pay, out of the moneys to be received under this scheme, to such officers and servants such reasonable wages, salaries, or allowance as they may think proper, and every such officer and servant shall be removable by the Conservators at their pleasure. 16. The Conservators may execute any works of drainage, raising, levelling, or fencing, for the protection and improvement of the Commons so far only as may be required for the purposes of the Metropolitan Commons Act 1866 and the Metropolitan Commons Amendment Act 1869, and may do any work necessary for the proper cleansing of the ponds on the Commons, and shall preserve the turf, shrubs, trees, plants, and grass thereon, and for this purpose may enclose by fences for short periods such portions as may require rest to revive the same, and may plant trees and shrubs for shelter or ornament, but shall do nothing that may otherwise vary or alter the natural features or aspect of the Commons, or interfere with free access to every part thereof. 17. The Conservators, subject to the provisions of Clause 39 of this scheme, shall maintain the Commons as delineated in the plan deposited with the Board of Agriculture free of all encroachment, and shall not permit any trespass on or partial or other enclosure of any part thereof, and no fences, rails, sheds, or buildings, whether used in connection with the playing of games or not, or other matters or things, shall be maintained, fixed, or erected thereon. Nor shall ice be taken off the ponds on the commons without the consent in writing of the conservators. 18. The conservators shall set apart such portion or portions of the commons as they may consider expedient for games, and may form any ground or grounds for cricket or other games, and may allow the same to be temporarily enclosed with posts and chains or other open fence, so as to prevent cattle and horses straying thereon. 19. The conservators shall frame bye-laws and regulations for the prevention of nuisances and the preservation of order upon the commons. The bye-laws may include all or any of the following purposes, viz. The prevention of encroachments and of the deposit of road sand, materials for the repair of the roads, dung, rubbish, flints, wood, or other matter on, and of the illegal taking, cutting, digging, and selling. The turf, sods, gravel, sand, or other substances from the commons, and of the illegal cutting, felling, or injuring the gorse, heather, timber, or other trees, shrubs, brushwood, or other plants for the time being growing thereon, and of the removal of ice from the ponds. The prevention of injury to, or the defacing or removing of seats, fences or barriers, or notice boards, or other things put up or maintained by the conservators on the commons. The prevention of injury to, or disfigurement of fences or trees on the commons by the posting of bills, placards, or notices. The prevention of bird catching, setting of traps, gins or nets, or liming trees, or laying snares of any description for birds or other animals, taking of birds' eggs or nests, and illegal shooting or chasing of game or other animals on the commons, or brought there for the purpose of being shot or chased. The regulation of games to be played and other means of recreation on the commons, and of assemblages of persons thereon. The prevention or regulation of vehicles being driven, or horses being exercised by grooms or others, on or across the commons. The exclusion, removal and apprehension, if necessary, of gamblers, card sharpers, gypsies, squatters, vagrants, sellers and exhibitors of infamous books, prints, photographs or pictures, or persons guilty of brawling, fighting or quarrelling, or using indecent and improper language, or any idle or disorderly person, so that all such persons may be dealt with according to law. Regulations with the view of preserving or restoring the natural surface of the ground, and as to place and mode of digging and taking gravel, sand, or other substances from and of cutting and felling of trees and underwood growing upon the commons, in exercise of any right of common or other right over or upon the commons. The prevention of unauthorized persons from turning out or knowingly permitting cattle, sheep, or other animals to graze or feed, or remain upon the commons, and generally for the prevention or restraint of any act or thing tending to the injury or disfigurement of the commons, or to interfere with the use thereof by the public for the purposes of exercise and recreation. Provided that all bye-laws made by the conservators shall be in writing under their seal, and the conservators may by such bye-laws impose upon offenders against the same such reasonable penalties to be recovered on summary conviction, as they shall think fit, not exceeding the sum of £5 for each offence, and in the case of a continuing offence, a further penalty not exceeding the sum of 40 shillings for each day after written notice of the offence. And the conservators may alter or repeal any bye-laws by other bye-laws sealed as aforesaid, and may make other bye-laws as they may from time to time think fit, provided always that all bye-laws imposing any penalty shall be so framed as to allow of the recovery of any sum less than the full amount of the penalty. Provided always that no bye-laws shall be repugnant to the laws of England or the provisions of this scheme, and no bye-laws or any alteration or repeal of any bye-laws shall be of any force or effect unless and until the same be confirmed by the local government board. Provided that a copy of any bye-laws signed and certified by the clerk of the conservators to be a true copy and to have been duly confirmed shall be evidence until the contrary, is proved in all legal proceedings of the due making, confirmation and existence of such bylaws without further proof. Provided also that no bylaws shall be confirmed unless notice of intention to apply for confirmation thereof shall have been given in one or more of the London daily morning newspapers, and a newspaper circulating in the parishes of Mitcham, Beddington and Wallington, and the county borough of Croydon, 1 calendar month at least before any such application. A copy of the proposed bylaws shall be kept at the office of the conservators, and be open during office hours thereat to the inspection of the ratepayers of the parishes of Mitcham, Beddington and Wallington, and the county borough of Croydon, and other persons interested without fee or reward, and the conservators shall furnish every such person applying for the same with a copy thereof, or of any part thereof, on payment of 6d for every 100 words contained in such copy. 20. The conservators are hereby empowered to agree, and they shall agree with the trustees of the recreation ground at Beddington Corner, delineated on the said plan, and thereon distinguished by an edging of red dotted lines, to take over from them the management of the same, and to pass bylaws and regulations for the public use thereof, subject to the following provisions. 1. That no bylaws or regulations relating to the said recreation ground shall be submitted for confirmation by the local government board unless previously approved of by the respective vestries of Beddington and Wallington. 2. That any expenditure required for the said recreation ground shall be a first charge upon any sums of money received by the conservators from Beddington or Wallington, either by way of subscription or donation or otherwise, and not given for any specific object or subject to any special conditions. 3. That whenever the site for a church and parsonage containing 1 acre, 0 rods, 20 perches, and now forming part of the said recreation ground, which was conveyed to the use of James McRae, Simpson Rostron and Bruch Maltby, in fee simple by an indenture dated the 1st day of April 1887, shall be required for the purposes mentioned in the said indenture, such site shall cease to be under or subject to the control of the conservators, and shall revert to the trustees for the time being of the said indenture of the 1st day of April 1887, who shall be at liberty to fence off and enclose the same. 21. Provided always that under no circumstances whatever shall the ratepayers of Beddington or Wallington, through their conservators or otherwise, be liable to contribute or pay any money for carrying into effect any of the powers or provisions of this scheme, unless such contribution or payment shall have been previously sanctioned on behalf of the said parishes, respectively by a majority of at least 2/3 in value of the ratepayers assembled at a meeting of the ratepayers called for that purpose, and at which the provisions of the Act 23 and 24 Victoria, c. 30, sections 4 and 5 shall apply. 22. All bylaws made by the conservators in pursuance of this scheme shall be printed and shall be sold to any person who may apply for the same at such price, not exceeding 1 shilling per copy as the conservators may determine, and all bylaws shall be legibly written or printed at length on boards of suitable size and placed on such parts of the commons, not less than 3, as to the conservators may appear desirable. 23. The conservators may from time to time, with the approval of the Board of Agriculture, purchase by agreement, or accept a conveyance of any estate, interest, or right in, over, or affecting any land formerly part or reputed or claimed to be part of the commons, or to be waste land within the parishes of Mitcham, Beddington, or Wallington, for the purposes of this scheme, and any such land, after it shall have been conveyed to the conservators, shall for all the purposes of this scheme be deemed to be part of the commons, and a plan of such land, scaled with the seal of the conservators, shall be forthwith deposited with the Board of Agriculture. 24. The conservators shall be at liberty to receive and apply for the purposes of this scheme or any of them, any subscriptions or donations applicable thereto that may come to their hands. 25. The conservators shall cause books to be provided and kept, and true and regular accounts to be entered therein, of all sums of money received and paid for, and on account of this scheme, and of the several purposes for which such sums of money shall have been received and paid, which books shall at all reasonable times be open to the inspection of any of the conservators and any ratepayer of the parishes of Mitcham, Beddington and Wallington, and of the county borough of Croydon without fee or reward, and the conservators and ratepayers or any of them may take copies of or extracts from such books without paying anything for the same. 26. The conservators shall cause their accounts to be balanced in each year to the 31st day of December, or to some other day to be fixed by them from time to time. 27. An auditor of the accounts not being a conservator shall be from time to time appointed by the chairman of quarter sessions for the county of Surrey, who shall fix his remuneration. 28. The auditor shall attend within 1 month after the day to which the accounts have been balanced at the office of the conservators, or at some other convenient place to be appointed by the conservators, and from time to time shall, in the presence of the clerk of the conservators, if he desire to be present, proceed to audit the accounts of the conservators for the year preceding such day, and the conservators shall, by their clerk or otherwise, produce and lay before the auditor the conservators' accounts, accompanied with proper vouchers and all books, papers and writings in their custody or power relating thereto, and any person interested in the accounts, either as a creditor of the conservators or otherwise, may be present at the audit of the accounts by himself or his agent, and may make any objection to any part of the accounts. And if the accounts be found correct, the auditor shall sign the same in token of his allowance thereof. But if the auditor thinks there is just cause to disapprove of any part of the accounts, he, or any other person interested in the accounts, may appeal against any parts of the accounts which shall be disapproved of, to one of the 2 next quarter sessions for the county of Surrey, notice in writing of such appeal being given to the clerk of the conservators, 14 days at least, before the hearing of such appeal. 29. Upon the hearing of such appeal, the justices may make such order as they think fit respecting the payment of the costs of the appellant out of the moneys coming to the hands of the conservators, or otherwise as they think fit, and such order shall be final. 30. For purposes of police, the Commons shall be deemed a place of public resort, and the powers and duties of police constables in relation to public safety and preservation of order and protection of property shall extend thereto. 31. Any constable or any officer of the conservators, and any person called by such constable or officer to his assistance, may, without any other warrant than this scheme, seize and detain any person offending or having offended against any bylaw of the conservators, who shall fail to satisfy such constable or officer as to his true name or address, and such constable or officer shall convey him with all convenient dispatch before a justice, to be dealt with according to law. 32. Proceedings with a view to the summary conviction of offenders under this scheme, or under any bylaws of the conservators, or to the recovery of any money or expenses authorized to be recovered summarily, or to any other order to be made by justices under this scheme or any such bylaw, shall be taken before a court of summary jurisdiction according to the provisions of the Summary Jurisdiction Acts. Any pecuniary penalty, expenses, or costs, or other money recovered by the conservators shall, notwithstanding anything in any other act, be paid to the conservators, and shall be applied by them for the purposes of this scheme. 33. A person shall not be disabled from acting as a justice or otherwise in any matter arising under or in relation to this scheme by reason of his being an elector under this scheme. 34. No proceeding to be had touching the conviction of any offender under this scheme, nor any order or other matter or thing whatsoever made, done, or transacted in or relating to the execution of this scheme, shall be vacated, quashed, or set aside for want of form. 35. The clauses of the Commissioners' Clauses Act, 1847, with respect to contracts to be entered into and the deeds to be executed by commissioners, and with respect to giving notice and orders proof of debt in bankruptcy or insolvency and tender of amends, as far as the same are applicable purposes of, and not inconsistent with this scheme, are hereby incorporated with this scheme. 36. The conservators may at any time apply for an amended or new scheme. 37. Saving always to all persons and bodies, politic and corporate, respective heirs, successors, executors and administrators, all interests or rights of a profitable or beneficial nature in, over, or affecting the commons, or any part thereof as they or any of them had before the confirmation of this scheme by Act of Parliament, or could or might have enjoyed if this scheme had not been confirmed by Act of Parliament. 38. The Lords of the Manors of Biggin and Tamworth, Ravensbury, Mitcham and Vauxhall, or of some one or more of such manors, claim the soil and freehold of the commons and the minerals thereunder. The Lords of the said manor of Biggin and Tamworth claim the right of holding a fair on Upper Green. The Corporation of Croydon, with respect to the piece of land situate at Beddington Corner, marked F1 on the said plan. The owners of Creef Villas, Beddington Corner, with respect to the piece of land there, marked F2 on the said plan. Captain Shackle of Elmhurst, Commonside, Mitcham, with respect to the piece of land marked F3 on the said plan. The Suburban Land and Cottage Company Limited, with respect to the piece of land marked F4 on the said plan. And Henry Hoare, Esquire, of Tamworth Lodge, Mitcham, with respect to the piece of land marked F5 on the said plan, respectively claim that the said pieces of land respectively are freehold property not subject to the rights of common. The owners and occupiers of lands and tenements in the parishes of Mitcham, Beddington and Wallington claim rights of common of pasturage and eastovers, and other rights over the commons. 39. This scheme is not to be deemed to affect or prejudice any rights of exclusive ownership in the said pieces of land F1, F2, F3 and F4 referred to in the preceding clause, nor the claims of the said claimants respectively, that the said pieces of land respectively are freehold property not subject to rights of common. 40. This scheme affects the rights in and over the commons so claimed as aforesaid only so far as is absolutely necessary for the purposes of this scheme, that is to say, by conferring on the conservators powers of management, improvement, and control as hereinbefore provided, and for such purposes the power of restricting, diminishing, or extinguishing such rights, or any of them, whenever it shall appear to the conservators that the continuance of such rights will interfere with the control, preservation, or improvement of the commons by the conservators, or with any of the purposes of this scheme, upon payment by the conservators of compensation to the bodies or persons severally interested in such rights. The amount, if any, to be paid by the conservators to such bodies or persons, as and for compensation in respect of the restriction, diminution, or extinction of such rights, shall be settled by agreement, or failing agreement, then under the provisions of the Lands Clauses Consolidation Act 1845, and the Acts amending the same, so far as the same relate to the purchase and taking of lands, otherwise than by agreement, including therein the several provisions relating to the compensation for common or waste lands, and thereupon the several provisions of such portion of the Lands Clauses Consolidation Act 1845, and the Acts amending the same, shall apply as if in all cases the word lands included interests, rights, and easements. 41. Provided always, that before the conservators take any proceedings under the provisions of the Lands Clauses Consolidation Act 1845, and the Acts amending the same, with respect to any estate, interest, or right of a profitable or beneficial nature, in, over, or affecting the commons, or any part thereof, they shall, if required, give security to the owner or owners of such estate, interest, or right to the satisfaction of the Board of Agriculture for the costs to which he or they would be entitled under the same Acts. 42. The Lords of the aforesaid manors have not consented to their rights being affected in the manner and to the extent herein expressed, but having regard to clauses 37, 38, 40 and 41, they do not oppose the scheme. Some of the owners and occupiers of lands and tenements in the parishes of Mitcham, Beddington and Wallington have consented to their rights being affected in the manner and to the extent herein expressed. Such of the owners and occupiers of lands and tenements in the said parishes, other than the said Henry Hoare, as have at any time opposed the scheme have withdrawn their opposition thereto. 43. Printed copies of this scheme shall at all times be sold at the office of the conservators to all persons desiring to buy the same at a price not exceeding 6d. each. 44. The costs, charges and expenses preliminary to and of and incidental to the preparing, applying for, obtaining and confirming of this scheme by Act of Parliament, and the expenses incurred by the conservators in the carrying out of this scheme, including the payment of compensation, if any, as herein before mentioned, may be paid by the conservators, out of any monies coming to their hands under the provisions, or for the purposes of this scheme. The Board of Agriculture, pursuant to the Board of Agriculture Act, 1889, and the Metropolitan Commons Acts, 1866 and 1869, hereby certify the foregoing scheme, in witness whereof they have hereunto set their official seal this 31st day of December, 1890. G. A. Leach, Secretary.